Okay. Paige.
Okay, hey y'all. Who here has ever watched Law and Order SVU? Or any kind of crime drama that are on TNT, ABC, all over? You've probably seen criminal trials everywhere for as long as you can remember. Unfortunately, that's not actually the way they work in real life most of the time. Whenever you're looking at a criminal trial, the first thing that's going to be decided is, are you going to have a trial by judge or a trial by jury? In a lot of states, a judge trial is not allowed for serious criminal offenses. I mean, obviously someone who's on trial for first-degree murder doesn't need their guilt and sentence decided by one human being. That's a lot to ask any person to take on. So jury trials are usually more common. You've probably seen those a lot. The jury selection is actually a really complicated process, and I'm not going to get into it a whole lot, but each side is basically going to try to manipulate the jury into being people that are going to be sympathetic to their case, if that makes sense. A prosecutor is going to want, hardline people who are going to go for the death penalty if that's what he's trying to convict. A defense attorney is usually going to want people who are more sympathetic, usually women. And then pretrial motions. Common requests are going to be for the exclusion of evidence. There are always going to be things that attorneys don't want allowed into the courtroom. The defendant's going to be required to enter a plea to say whether they're guilty or not guilty. And a really common request is going to be a plea bargain. Plea bargains are usually decided before the trial ever starts. 97% of federal cases and 94% of all state cases end in plea bargains. So they stop right here and they never actually make it to trial. In the trial itself, you get opening statements. The prosecution will go first and they will present their case. They basically just lay out, this is why this person is guilty. These are the elements of this crime. They committed all that, and we're going to prove that to you. The defense is going to step up in their opening statement, and they're going to say that this person is not guilty and they don't have proof, the usual attorney stuff. The state will present their case. They'll bring up their witnesses. Usually after the state rests, the defense is going to move to dismiss. They're going to say that the state didn't prove their case. That request is almost never granted, but I guess at that point they think it's worth a shot. The defense is going to present their case. Following that, they'll bring up their witnesses, and then they will rest, and then you will give closing arguments. The prosecution does have to go first again, and then the defense is allowed to give their closing argument. The prosecution is allowed to do a rebuttal argument. They are allowed to have the last word. Post-arguments, the jury will go, they'll decide, they'll bring back the verdict, the judge does the sentencing, and then of course there are always appeals in the event of a guilty verdict. Appeals are also a very complicated process because you're constantly appealing to a higher court, but they do happen. Some things to keep in mind whenever you're looking at a trial going on, whenever each side is presenting their case, whenever they're talking to their own witnesses that they've brought up to prove their case, they cannot lead, as in they cannot ask questions like, and you were there, correct? They can't suggest an answer to a witness. The witness has to answer of their own volition. They have to give their own answer, if that makes sense. But whenever you are talking to the other side's witness, you can lead. You can suggest answers to them. It's a way to trip people up on the stand. It usually works pretty well. The burden of the proof is on the state, meaning that the prosecution has to prove their case. The defense has to prove absolutely nothing. All they really have to do is poke holes in the prosecution's argument. And these are some common objections. I know everybody has seen the objections a lot of times on TV. They actually don't make sense. But leading, which is what I just talked about, you can't lead to your own witnesses. Relevance, like you've seen attorneys, they'll ask questions that just seemingly came out of nowhere and they don't make sense. A lot of times they have a point there, but you can sometimes shut that down and get that dismissed. Argumentative, believe it or not, attorneys actually aren't supposed to argue. They're not supposed to suggest things that are going to make people blow up or anything like that. Asked and answered, it doesn't matter how many different ways you rephrase a question. You cannot ask the same thing over and over again. And if it's been asked by another attorney, it's considered asked and answered for the record. Hearsay, you cannot testify as to something that you heard someone else say. I can't get on the stand and say, well, I heard Devin say that he was going to do whatever. Doesn't matter. I heard it, sure, but I didn't say it. Speculation, you can't ask a witness to talk about what they think might have happened. It's useless. A court of law is usually very black and white, or they try to be. You don't have the time for speculation. And then an improper expert opinion. In the event that you have someone like a psychologist or a doctor on the stand, they are allowed to testify to the more technical aspects of the case, but you have to qualify them as an expert witness first. Their credentials have to be presented to the court, and the court has to approve that. If you don't do that before they start testifying, then they're considered, you know, the testimony of a doctor or a psychologist would be considered as if I had said it, and I don't have a degree in either one of those things. And so a lot of times, that's an easy way if an attorney forgets to really dismiss something that could have been really helpful to a case. And do y'all have any questions for me? All right, thank y'all.
Cool. So you're going into criminal justice?
Yes, sir.
You're going to be very successful. Good job. Good, good. All right. See y'all. Have a great Hey.
I know I've been absent because of class and stuff. This Friday I had softball, just so you know, because I said I didn't tell you, I don't know if I told you. And then we didn't get back till like 2 or 3 o'clock in the morning.
When were you scheduled, or are you scheduled
I have
for
not
later?
scheduled.
Okay.
So,
All
if
right.
I need to write my name down somewhere.
Yeah, send me an email with that.
I have to try to email you, I don't know if you're getting it, because I sent you one the other day about not being in class or something.
You were doing my Gmail account,
I'm not sure.
and it may
No,
be.
I actually went through the school website.
Oh, okay. My Gmail account is the one to
Okay.
use because I don't have that. Heather,
Is it
let me look at you. You're getting better.
Yes.
Good, good.
Intolis@gmail.com?
Yeah, that's it.
Okay.
Yeah, just send it there. And you may have sent it to me and I just didn't respond or something.
Okay.
So,
All right.
all right.
Thank you.
You bet. How's the season going?
Pretty good. We got 2 home games tonight.
Oh, cool. Here?
Yes, sir.
Excellent.
Yeah.
Might have to drop by there.
Okay.